In the subject of administrative law, which has been my kind of professional lifetime occupation, there's an enormous field called administrative adjudication. So these are dispute settlements, often through trials that occur within administrative agencies rather than courts. And there's vastly more adjudications that are administrative than there are cases in court. So we in the administrative law field usually think about administrative adjudication as requiring pretty formal trial type hearings that aren't so different from the ones that you see in court, except the judges don't wear black robes and they don't do it in courtrooms. So that's what we mostly talk about when we do administrative law, are these quite formal trial type hearings presided over by someone called an administrative law judge. But that obscures the fact that a vast amount of state and federal administrative adjudication isn't in formal trial type hearings at all. We have disputes between the private party and the government, but they are settled by very informal means, such as a presentation of data, negotiations, conferences, public notice and comment, mediation, all kinds of decision-making methodologies that aren't trial type hearings. But no one really talks about that very much. And that's for a good reason. There are countless schemes of informal adjudication, just now talking about the federal government rather than the states. But every one is different from the others. There's no commonality at all. So that makes it hard to study and hard to get a handle on this sector. So my article is designed to alert people to the fact that there is this enormous sector of informal adjudication. And once we recognize that, then we as administrative lawyers think, well, what are the procedures that are being used, and are they fair and efficient? So I did a study for an agency called the Administrative Conference of the United States. So most of your listeners probably have never heard of this agency, which we all call ACUS, Administrative Conference of the United States. But it's the best little government agency that you've never heard of. It's nonpartisan, has a very small budget, and among other things, it makes recommendations for good government that cut across party lines. And it often hires consultants, and I've worked for ACUS as a consultant for many years. And I did a consulting project on this subject of informal adjudication that came up with a series of recommendations for best practices that agencies could voluntarily follow in trying to improve their informal adjudication procedures. Now, since every one of these is different, some of those best practices have to be tailored to the specific circumstances involved. There's a vast array. There are thousands of different informal adjudication schemes just within the federal government. So I'll just mention a few of them. If we're talking about federal grants and loans and benefits, most of the determinations are informal. So let's say you apply to the National Science Foundation for a grant for your particular scientific project, and the government, it's a competitive process, lots of people are applying for this money, and they turn you down. And what can you do about it? Can you get a hearing where you try to demonstrate that your proposal is better than the ones that got accepted? No, there are no hearings. But there is an informal process by which you can appeal the denial of your application, in which you get another set of eyes looking at the problem. Maybe the initial reviewer was wrong or incompetent or biased or whatever. You do get a chance to make your case that you should have received this grant, but it's all through informal adjudication. The same is true of applications for banking charters. You want to open a new bank in your town, but the existing banks don't want you for obvious reasons. This procedure is this application, very important. I mean, a lot of money is involved. is all handled informally. So that's one big area. Another might be visas. You apply for a visa to the United States in a foreign country, the local counsel turns you down. Can you get a hearing? Because he turns you down because he thinks you're a security risk or whatever. And you say you're not. No, there are no hearings. But there is an informal procedure by which someone else within the agency can take a look at the counsel's decision. And there are just a vast number of other disputes between private parties and the government that are resolved through informal techniques. We think there should be a system of proper notice to the private party that his or her application or whatever it happens to be, a sanction or a benefit, has been denied, and the reasons why, so that you have a chance to try to overturn them. We think there should be an opportunity to do that through the presentation of written evidence and discussions and negotiations, whatever it takes, but a process whereby there's a way you can challenge that, what we call a frontline decision that denied you what you wanted or suggested imposing a sanction on you. We think you should have a right to be represented by a lawyer or by a non-lawyer, a lay advocate, if you can't afford a lawyer. We think that the decision makers should be free from conflict of interest. We feel there should be, if you lose, we call that the primary decision phase, where you actually have a chance to come in with written evidence and to make oral arguments and negotiations. If that fails, there should be a review process within the agency. Someone else should put a second set of eyes on the problem. We think there should be a statement of reasons as to why you're being rejected or sanctioned, so that you have a possibility of challenging that decision in court. But you can't challenge it in court unless the court can figure out why the agency made the decision. So you need a statement of reasons. We think there should be access to an ombuds. So lots of your listeners have never heard that funny sounding term. But the ombuds, or sometimes referred to as ombudsman, which is what they're called in Scandinavian countries. These exist all over the place in the government, and we think there should be access to one. So an ombudsman, or ombuds, has the power to investigate what happened and to make recommendations about what to do about it. The ombuds has no formal power, can't force the agency to do what you want, but they're very powerful through what's called soft power. The agencies don't want to irritate the ombuds, so they usually follow what the ombuds suggests. And there's lots of things that ombudsmen can look at that really aren't legal. For example, I was treated in a rude manner. They weren't civil to me. They wouldn't explain. They gave me the brush off. They gave me the runaround. These kinds of complaints are what ombuds are good at looking into. So because you don't have the protection of a formal hearing, we think it would be a good thing that you'd have access to an ombuds. So those are some of the more important recommendations that the administrative conference made. But we always have to realize that informal adjudication is a huge range of very important issues like the banking charters or denial of a visa. And there are some really trivial examples. The one that's always used is if you and I both apply for the last campsite at a national forest campground, the forest ranger will say, I get it, and Sam, you can leave. Well, that's an adjudication, right? That determined who was going to have the right to occupy government property for a single night. But it's not very important in the great scheme of things. You wouldn't want to over-proceduralize that. The ranger has to make a decision and move on. But even the ranger should explain to you why you didn't get the site, like Michael got there first. But you wouldn't over-proceduralize that. You probably wouldn't have review by another official because the other official isn't there. It has to be decided on the spot. But when you're talking about denial of bank charters or denial of an application for a grant, that's much more significant in money terms. So more procedure should be needed. So the agency has to decide for itself how to tailor our best practices to the actual situation involved. The implications first are simply to alert all of us administrative lawyers, the people who teach this subject at all the law schools, as well as all the private lawyers and government officials who are involved with administrative agencies. They need to think about informal adjudication in a holistic manner, rather than just as a couple thousand completely different and unrelated and pretty irrelevant dispute settlement schemes. It's a lot more than that. So part of the job here is simply to alert people, to tune them into the existence of this very large area of government dispute settlement that calls for more uniform approaches than have been available so far. But realizing that you can't solve this problem through a new statute or something like that, because the various schemes are too different from each other. And then secondly, to encourage agencies to take a look at their informal adjudication practices, which they may never have done. And think about, well, could we improve this system of justice? You know, Sam, these disputes are everywhere. And how the government acts when it has such a dispute, it's really the face of justice for vast numbers of people, and people deserve to be treated fairly but yet efficiently in this scheme. So it's designed to get agencies to take a look at this process, see whether they could really make it both more fair but also more efficient.